my knowledge.
Yes.
I'm going to move to the second document that phones for you complains about the judge failed to refer to a judgment in the context of the Dunn-Lawrence allegation.
Yeah.
And you will find that document at Core Supplemental Bundle, tab 18, page 62. So this is an internal text sent by Mr. Evans, who was O2 CFO, to Mr. Dunn on the 2nd of January 2013. Obviously shown this by Mr. McLean. Our gross connections through indirects were very high, potentially as a result of EE in dispute. Reassuring OLAF, given our impending move, may be helpful to strengthen the operator's resolve against the indirects. Now, stating the obvious, the only mobile operator specifically referred to in this text is EE and Mr. Swanty. There is no mention of Vodafone or Mr. Lawrence. It is therefore not surprising that this text was specifically addressed in the part of the judgment dealing with O2 and EE. And if we can go to the judgment, Core Bundle, tab 18, page 317. This is in paragraph 198. This is in the section of the judgment dealing with the landmark lunch. And you'll see 198 sub C. There's quite a long discussion of that particular text and the judge's conclusions in relation to it. And the details of those findings don't matter for this purpose, because we're concerned for the moment with Mr. Dunn and Mr. Lawrence. And what is now said is that the fact that Vodafone was not mentioned in the text demonstrates that Vodafone did not need reassuring because there had been collusion between Mr. Dunn and Mr. Lawrence. That's the way it's put. So if you like, it's sort of inference by omission. And the simple point we make in relation to this is that the suggestion that this really could have moved the dial, given how speculative and second order it is, means that Phones View's submissions on this should be given short shrift. And I don't really have anything else to say in relation to that. It's simply so peripheral.
Okay.
We shouldn't really worry about it.
The
second aspect.
The point.
I'm so sorry.
The point, I think, to be fair, is it's referring to the operator's resolve as though it is a single thing, as it were. And where does that come from if there's been no collusion?
It's not for me to give evidence, but let me make a suggestion, which is this. As we've seen from the judgment, it was well known that all the main operators, all the main MNOs, would rather that they didn't have to deal with the indirects. And that was particularly the case for the sorts of companies we're looking at who were pan-European, and they didn't have to deal with indirects in Europe, and they resented the fact they had to deal with indirects in the UK. You may have got a flavour, I know you won't be, I've seen all the detail, but part of O2's reasoning, one of the reasons it reached the decision to exit unilaterally as the first person to do so, was that there was a belief among certainly some of the team, both in the UK and at the Telefonica level, that if O2 pulled out, they thought it would be rational for the other MNOs to see what was happening and to follow suit. Not as a result of any collusion, but simply as a result of taking similar commercial decisions. If O2 is brave enough to come out and others follow, they can see that that might weaken the indirects. So the reference to strengthening operator's resolve against the indirects could simply be a reflection of that. It doesn't necessarily have to be some pre-existing collusion between the indirects. But that's, I make that absolutely clear That's not, I mean, the general evidence I've referred to is there, but that's not a particular witness I can take you to who said that was the meaning of resolve in this particular text.
Right.
The second aspect of the Dunn-Lawrence allegation is in ground 5 of Phones for Use, grounds of appeal, and that's a failure to consider evidence in the round. And just in short, and I hope I do it justice, Phones for You argument runs like this. At the landmark lunch, Mr. Dunn referred to both 4G pricing and indirect retailers. Mr. Lawrence made a phone call to Mr. Swanty about 4G pricing. Mr. Dunn met Mr. Lawrence before Mr. Lawrence made his call to Mr. Swanty. The judge found that it is highly likely that Mr. Dunn and Mr. Lawrence discussed the call that Mr. Lawrence later made to Mr. Swanty. And Phones for You says it should therefore be inferred that Mr. Dunn told Mr. Lawrence that O2 was planning to pull volume from indirect distributors. That's, as I understand it, is the chain of arguing of facts leading to an inference. And in our submission, there are a number of reasons why that submission should be rejected. The first one is this. The suggestion that the judge failed to consider this evidence in the round is incorrect. It's the judgment at page 329. Paragraphs 237 to 241. If I could ask you to read those paragraphs, please. 237 to 241.
We have a look at 241.
And the submission.
And you made the point that 242s where it emerges that the specific allegation wasn't actually pleaded until February 22.
That's right. On this point, what I'd like to show you to make good is that the specific point now being made by Phones for You was expressly considered by the judge. And you see that at 239 sub A, where the judge says, just above A, P for You contended that since Mr. Dunn had sought to de-risk O2's position as regards EE, it would have been equally relevant to seek to do so with another MNO for which TFEU obtained connections. And this is all in the context of the Mr. Lawrence allegations. So the judge recognises the argument that Phones for You put then and is putting to this court now, and he addresses it specifically at 241. I accept, for the reasons advanced by Phones for You, that it is possible that Mr. Dunn made a similar approach to Mr. Lawrence to the one that he made to Mr. Swanty during the landmark lunch. But this is speculative, and I find that there is a wholly insufficient basis on the evidence to support such a finding on the balance of probabilities. So this is not a built-up point, because built-up has been relied upon in the grounds both as failure to refer to documents and failure to consider evidence in the round as a result of delay. And as I've just shown you, this particular argument was considered in the judgment. It's simply not a built-up point. I don't understand Phones for You actually to be running an appeal on the basis of not rationally within the bounds of what the judge could have found. I can address you on why the judge was entitled to find what he did, or to draw the conclusion that he did, but I don't understand that to be the base on which the appeal is put. This is grounds 4 and 5 have been very firmly put as built upon. I probably should just say what the answer would be.
Well, I mean, this is the point where the judge had all there was in terms of evidence, other than the fact the meeting had taken place, was Mr Dunn's evidence, which the judge says he accepted, that he can remember.
That's right.
Mr Lawrence didn't give evidence.
That's right.
And there was a good reason for that. The criticism that they could and should have taken a witness statement from him at an earlier stage was defeated by the fact they hadn't actually made the allegation until February 22. Right. End of point so far as the evidence was concerned.
And the judge finds they're not proven.
And you know, it may be that TFEU don't like it, but as you rightly say, that this particular one doesn't seem to have anything whatsoever to do with the fact the judge took 15 months producing the judgment.
Now, I made it plain that I didn't understand TFEU were making a point beyond built on grounds 4 and 5, and nobody's corrected me from either side.
No.
So I'm going to take that as an invitation not to go into develop an argument in relation to ground of appeal that hasn't been raised, i.e. the judge wasn't really able to reach this conclusion. I meet it fair and square as a built-up point, and I'll show you why it's not a built-up.
Yeah, okay. Right.
That's all I want to say on Dunn Evans. You're going to hear from Vodafone, but unless you have any further questions for me, I'll sit down for a moment.
No.
Thank you.
Thank you.
Well, my lady, Mr Michu has made the point that in dealing with grounds 4 and 5, the court needs to consider TFEU's specific points in the context of the evidence as a whole, and for the court's note, we made that point in paragraphs 4 and following of our skeleton argument. I'm going to focus first on the Dunn and Lawrence allegations, but quite a lot of what I'm about to say by way of introduction to the issues is also relevant to the next ground relating to O2 and Vodafone concerning Hum and Castillo. So I'm going to make some general points which will apply to both issues. The court has seen paragraph 50S of the particulars of claim where this issue was pleaded, and in exchanges between Mr Hoskins and the Chancellor, you just touched on the fact that there was no evidence to support the allegation. It was a case advanced purely on the basis of inference and the inherent probabilities, as Mr McLean has explained to the court, and one sees the way the case was put in paragraph 239 of the judgment, which Mr Hoskins has just shown you. Can I just show you where this allegation fits into the general collusion case, please, in the particulars at 558, because it's relevant to how the judge dealt with this issue and the next issue. It's core bundle tab 21, page 558. So this is where the particulars.
Sorry, hang on. Where are you in the judgment?
I'm in the particulars of claim. I'm sorry.
Oh, in the particulars of claim. Sorry.
I think it's on the screen.
Okay.
So just to sketch this out, this is where the legal allegation is pleaded. We've looked at some of the factual background. This is the legal allegation, and the structure of the allegation is that in 131 there is an allegation of collusion whereby disclosures or commitments were made by Telefonica to Vodafone, and what we then see is a later plea that was reciprocated. And one can see from this paragraph and in all the subsequent paragraphs that the date given is 19th of September 2012. And one can see the way it's put. It cascades down with various different levels of commitment, and starts with a commitment to reduce supplies to TFEU, and it finishes with a commitment to reduce reliance on retail intermediaries in the UK, so it becomes less specific. And then if the court looks at B, one can see that, so A is commitments and B is disclosures, and the disclosures are essentially dealing with the same subject matter. And so the court will see that the first part of the pleading, the commitments case, reflects what Mr Dunn said to Mr Whiting, that's the basis on which this was pleaded. He didn't say it happened in 2012, but TFEU had to say that the collusion happened at this point in 2012, because that was prior to the O2 decision, and its case was that the decision had been infected by collusion at that time. So that's why they pin it on 2012. And if we then move on to 131A on 559, this refers back to paragraph 50S, which Mr Hoskins showed you, and this is now O2 or Telefonica. The previous paragraph was commitments by Telefonica, but now we move to Telefonica or O2, and again it's tied to September 2012, and we do say that this does appear to explain why we see Phones for You going to somewhat extreme lengths to devise a case that something happened in or around September 2012, because its whole case that the O2 decision was infected depended on something happening in this window. And if we then look down to 133, this is the paragraph where Phones for You pleads that any commitments or disclosures were not unilateral, but were provided in return for equivalent commitment or disclosure from Vodafone Group or Vodafone UK. And they go on to say that it's inherently improbable that any undertaking would give a commitment or make a disclosure without it being reciprocated. And that was an important part of Phones for You's case, because the case started with an allegation of a one-way commitment, and in order to get the case going, that there was reciprocal collusion, they had to rely on the logic in 133. And so that was the basis on which it was said that it was inherently likely that there would be commitments, because it was inherently unlikely that anyone would have given a one-way commitment if they didn't get something in return. And one can see that case is advanced in relation to the exchanges with O2 in September 2012 as well. So that's the Dunn-Lawrence case. It's fair to say that in their supplemental skeleton argument, paragraph 71.3, Phones for You has sought to walk back from paragraph 133 and sought to say, well, it doesn't all exactly have to be reciprocal, but this really was a fundamental part of its case. It was pleaded in relation to this issue and all of the issues, and it was never retracted. So the shape of the case is that in September 2012, O2 was considering a move out of Phones for You, and it looked to Vodafone for comfort about how it would react. And one can immediately see that the allegation isn't just total speculation, it just doesn't fit with what is known about Vodafone's decision-making. In September 2012, Vodafone didn't have a strategy in relation to the indirect channel which it could disclose. It didn't have a plan to reduce its reliance on Phones for You or Carphone Warehouse for that matter, and it didn't have any such strategy for another 18 months to 2 years. The court's aware that Vodafone didn't decide to exit Phones for You until June 2014. That's paragraph 375 and following of the judgment. And that strategy didn't really start to emerge until negotiations with Phones for You became difficult from around the end of March 2014. And during almost the whole of the intervening period, it is not in dispute that Vodafone's strategy was actually to stay in Phones for You and to do a new deal with Phones for You. And if we can just pick that up in the judgment at 353. And the section, if we could scroll down to paragraph 329. So this is the section of the judgment dealing with the Vodafone decision. You can see that the discussion starts in November 2013. And there's a long section discussing this. But if we could look at 333, please, on the next page. It says there's reference to Vodafone having an intention to have fewer indirect partners, but Mr Whiting said in his conversation with Vodafone he was assured they wanted to maintain a strong relationship with Phones for You. This wasn't disputed by Vodafone UK, and so on and so forth. So at that point in time, Vodafone's express intention is to renew and sustain its relationship with Phones for You. And Mr Hoskins has made the point that at the beginning of this window, Vodafone actually went deeper into Phones for You and took up additional volume. And the references to that are 292 and 316 of the judgment. And then, as the judge found over the subsequent months, Vodafone changed direction for a number of reasons. The commercial negotiations broke down, Carphone offered a much more attractive deal on exclusive terms. The strategic case for Phones for You changed with the merger and because of the last man standing issue and so on. And so the picture changed. But 333 is the position at the outset of those negotiations. And that is December 2013, and the position runs on from there. So if we could now move on to 381 of the judgment, please. 381 of the core bundle. It's paragraphs 421 and 422. And this is where the judge draws some of his conclusions about the alleged collusion with O2. 421 is a neat summary of the different strands of Phones for You's case. And if you could look at 422, please. So January 2014 is the Dunn-Whiting meeting. It is also the point in time at which O2 finally and publicly exits from Phones for You. And the judge has expressly found in 422 that at that point in time, Vodafone, the development of its strategy, wasn't seriously contemplating an end to its relationship with either Phones for You or Carphone at the time. So Vodafone didn't have a strategy to disclose in 2012, or indeed November 2013 for that matter, as we'll come to. And the judge found, in line with Phones for You's own case, that there would have been no exchange of strategic information if it wasn't reciprocal. So the judge accepts Phones for You's pleaded point in paragraph 133, but he finds that it militates against Phones for You rather than in its favour. So that's why we say in paragraph 9 of our skeleton that this part of Phones for You's case doesn't work. Vodafone and O2 were ships in the night. They were never contemplating reducing their use of Phones for You at the same time. And that was the position as late as January 2014, let alone September, October 2012 or November 2013. So the 2012 allegations, coming back to the 2012 allegations, they start from a point where there is no evidence to support the allegations. And by this point, the prospect of collusion and cooperation between Vodafone and O2 is improbable even on Phones for You's own pleaded case, because the facts are simply inconsistent with any sort of reciprocal collusion.
But the allegation of collusion against O2 is slightly different, isn't it? It's what O2 was looking for was an assurance that the other MNOs wouldn't take up the volume that they were proposing to give up. It's not that they would require a mutual agreement that the other MNOs would pull out.
Well, I'm going to come to the slide deck in a minute. As the court's seen, what that slide deck, I mean, focusing on the ground 4B point, the slide deck that Mr McLean relies on says Vodafone will assume Vodafone will follow. So that document, which is said to support this part of the case, is about whether Vodafone had a plan to exit Phones for You. So that's part of the reason for developing this.
But the rationale of Mr Dunn's approach to Mr Swanty, the very same rationale would have applied to Mr Lawrence.
The rationale for him to want to... That rationale... Well, yes, I mean, in the sense that his concern about other MNOs taking up the volume, that's true. But the
point that Phones for You make is, if Mr Dunn was prepared to blatantly go to Mr Swanty and say what he said, why would he not have said that to Mr Lawrence as well? I mean, it's difficult to understand why he wouldn't.
Well, but there isn't any evidence at all that he did it.
No,
and
appreciate that.
Yes.
That's their case.
Yes. I'm going to come
and it's not dependent upon Vodafone at that point considering an exit, which seems to be your answer to it.
Well, it is the prospect that Vodafone would have engaged with and reciprocated with that proposal does depend on Vodafone's attitude to dealing with Phones for You. Sorry, that's the point I'm getting to, which is that the idea that Vodafone would have been receptive to that really depends on Vodafone having a strategy under which it is, at that point in time, seeking to reduce the extent of its relationships with Phones for You, rather than, as my Lady Justice Falk has put, rather than taking the opportunity to go further into Phones for You. And as the court's heard, in fact, Vodafone did subsequently go deeper into Phones for You. So the answer to your question, my lord, is that this really probably goes to the Vodafone reciprocation side of it, rather than whether Mr Dunn would ever have had the incentive to make the approach. But it does come back to the judge's point about reciprocation. Phones for Use cases, this wouldn't have happened unless there was something reciprocal going on. And everything we know about Vodafone's strategy at this time is that it just wasn't going in that direction. So we say this was always an exceptionally weak case. The judge found that it was speculative and there was a wholly insufficient basis in the evidence for it. It's notable that it piggybacks on the Dunn's Swanty allegations, and of course the judge found that those allegations didn't sustain an infringement, even where there was evidence that the conversation actually happened, and so this position, our case, is a fortiori that. So that is context for this. Mr Hoskins has dealt with the two documents, so just to make a couple of brief points about them, going back to Core Supplementary Bundle, tab 1355. Yes, so if we could scroll down to point 5, please. And so this is part of my answer to my Lord Phillips's point about, this is the document that's said to support the case. And the point that's made in 5 is O2 withdraw from Phones for You in January 2014. And then it says assume Vodafone follows suit. But the idea that Vodafone might have been telling O2 in or around September 2014 that it had plans to follow suit. 2012. That it had plans to follow suit if O2 did this in January 2014. And it's completely at odds with all of the evidence, both about whether Vodafone had started to think about the issue and about what its plans were when it did start to think about the issue. And in January 2014, Vodafone was in fact still intending to stay in Phones for You. So it's just completely at odds with the known facts. So that is that point. Sorry, and the way Mr McLean put it on Tuesday was he said, well, this slide shows that O2 knew enough about Vodafone's thinking. But I mean, what was that thinking? I mean, all of the evidence is that thinking didn't exist for more than a year afterwards. And then the second document is the text message at tab 18 of this bundle, page 62. And I adopt Mr Hoskins' submissions. The way we put it in our skeleton is to say, the argument here is that the court should have inferred that there was collusion between Mr Dunn and Lawrence, because what we see here is no evidence of further collusion. The absence of evidence is said to be explained by the fact that there had been earlier collusion, but there isn't actually any evidence of that earlier collusion either. So we do say that this is invention. And Mr Hoskins has addressed my Lord Phillips' point about the word operators plural. So that's ground 4 on this issue. And the case under ground 5, as Mr Hoskins has introduced it, is that the judge failed to consider the evidence in the round, and essentially that he overlooked the fact that there was a degree of overlap between Mr Lawrence's conversation with Mr Swanty and Mr Dunn's conversation with Mr Swanty. And obviously the judge identified that overlap, and he said, well, the overlap relates to 4G pricing, and that doesn't help Phones for You. So we are back to the idea that without any evidence, the judge should have inferred a specific collusive conversation between Mr Dunn and Mr Lawrence from a different conversation with a different person weeks previously. And so in relation to this issue, I continue to rely on the points I've made about the state of Vodafone's strategy at this time, its thinking, the fact that it had no plan to reduce its reliance on Phones for You, and in fact that subsequently went deeper into Phones for You. Obviously we say that has to be brought into consideration, as the judge did at 422. I adopt the submissions Mr Hoskins has made. Just for the court's note, I don't want to take up time, but if the court goes back to paragraphs, well, maybe we should just make sure I give you the right reference, 316 of the court bundle. So this is the judge's factual discussion. You can see 194 is dealing with the landmark lunch, and 195 is going on to discuss the landmark lunch. And there's a reference in the first few lines there. It is true that Mr Dunn, unlike Mr Lawrence and Mr Harrison in telephone calls a few weeks later, did not mention a specific price. This is another part of the judgment where the judge brings the two episodes together when he's considering what happened. So again, he has considered them in the round. He's obviously not accepted Phones for Use suggestion that the two conversations came to the same thing, but he's clearly considered them alongside one another.
Really sorry, I couldn't hear that, so I'm afraid I don't think the transcriber could either. Can you say it again?
Sorry, I just realised my microphone is pointing in the wrong direction. Yes, I was just saying that these are some more paragraphs where the judge is dealing with both the landmark lunch, and he brings into account at the start of 195 the evidence about what happened with Mr Dunn, between Mr Lawrence and Mr Harrison subsequently. So he's again considering the fact patterns alongside one. The suggestion is that he hasn't considered them a lot. He hasn't considered the overlaps. He hasn't considered the two conversations alongside one another and what the implications of one is for the other. This is just another point in the judgment where he does that. So just two more brief points in relation to this ground. First of all, Mr McLean says that the inherent probabilities support his argument. And it's important that the judge reached the conclusion he did because Mr Lawrence had two conversations on the same day, 10th of October 2012. He had a conversation with Mr Dunn and a conversation with Mr Swanty. That's dealt with in the judgment at 313. And the judge inferred that Mr Lawrence was likely to have had the same conversation on both occasions. And in my submission, that finding does reflect the inherent probabilities. What the judge has done is said, well, it's very likely that these two conversations were pointing in the same direction. But the conversation Mr Dunn had with Mr Swanty was not a discussion about indirects. It was a discussion about the 4G pricing premium only. That's the evidence. And obviously Phones for You invited the court to go much further and to draw inferences that the conversation went further. But that wasn't the evidence. That wasn't Mr Swanty's evidence. So the judge's findings, in my respectful submission, clearly do reflect the inherent probabilities. And there's no dispute that on Mr Swanty's evidence, the conversation Mr Lawrence had with him was materially different from the conversation at the landmark lunch because it was focused on a specific price increment for 4G over 3G, and that he didn't raise the concern about discounting through the indirect channel. So they were materially different conversations. So that's the first point I wanted to make about inherent probabilities. But the second point is the point which Mr McLean described as ridiculous yesterday. But having heard his submission, I couldn't understand why it was ridiculous, and I couldn't even really understand what his answer to the point is, if I may say so. But I'll explain the point to the court. The whole thrust of this ground is that what Mr Dunn said to Mr Swanty about supplies to indirect retailers, and what Mr Lawrence raised with Mr Swanty about 4G pricing, were a single concern, and they resulted in a single collusive plan. And I'll show you why I say that. It's Phones for You skeleton argument, 182, at Core Bundle 3, page 74. So could the court just read paragraph 182, please? So Mr Dunn's approach to Mr Swanty was broadly about controlling 4G pricing by reducing supplies to the indirects. The objective was to be achieved at the expense of the indirects. But the judge found that Mr Lawrence made his approach to Mr Swanty in coordination with Mr Harrison of Carphone Warehouse. This is paragraphs 164 and 169 of the judgment. And so the suggestion seems to be that Mr Lawrence was part of a single collusive plan which sought to reduce the volume of supplies to the indirect channel, in which he also involved Mr Harrison of Carphone Warehouse, one of the two main indirect suppliers. So Carphone Warehouse was part of a single collusive plan to hamper its own business. And that's why we say that the allegation really isn't coherent. And I couldn't understand from Mr McLean's submissions yesterday what he says about that point. But it's probably a second order point, because, for all the other reasons that the court has heard. So that is grounds 4B and 5A as far as Vodafone is concerned. And I'm going to move now to ground 4C, which is Hum Castillo. So if we could just go back to the particulars, Core Bundle 21, 512, 513. This allegation is pleaded at 50T. And there is green text which reflects the pleading that was added after the disclosure, where it said that there's an inference of discussions of O2's exit from Phones for You and its attitude to any future relationship with Phones for You. So that is vague language. There's no explanation of what that future attitude is supposed to be, other than in the context of the decision to leave Phones for You. Now, my submissions about this ground incorporate as a starting point the submissions I made in relation to the previous ground about the allegation, about the point at which Vodafone's strategy started to develop. But I say that because the allegation of collusion between Ms Castillo and Mr Hum relates to a meeting in September 2013. And at that point, Telefonica it had withdrawn new connections and it was considering whether to withdraw SIM-only and upgrades. And I've shown the court the state of Vodafone's decision making at that time. The meeting occurred before Vodafone had even started to consider its strategy, which started from the proposition that Vodafone would stay in Phones for You. And that was still the position by the time O2 was fully out of Phones for You. So the submission I made earlier that the allegation of collusion doesn't work because the two businesses weren't in sync, that also applies to November 2013. O2's strategy was settled and executed before Vodafone went anyway.
Just remind us exactly when the final decision was made by O2 to exit.
It was October.
It was during 2013, but later.
That's right. I can check it and I'll give it. I think it's around October 13. I just need to.
So O2 was well into consideration of its strategy at this point. I think the decision came slightly after. You'll see in the judgment, the judge deals with this at 291. But for its part, Vodafone, just the process hadn't even started. You saw the reference to the process starting in November 2013. And this was central to the judge's reasoning in the judgment. The courts heard that this issue was focused on Mr Hum's out-distribution note. And both Mr Hum and Ms Castillo were cross-examined in detail about that. Phones for You said that it was a discussion of future strategy, and the witnesses said that there wasn't a discussion or they couldn't record a discussion. And the judge found that he didn't accept that the matter wasn't raised at all, and he thought Mr Hum would have raised the matter that he intended to raise, which is how O2's exit from Phones for You was going. That's the end of 289 and 290 of the judgment. But the judge's reasoning starts at 291 on 343, and he found that discussion of how it was going was very different from giving or receiving commitments or discussing future strategy. and he found that there was no discussion of future strategy. And there are two main points in 291. The first is the point I've already made, that Vodafone had no information to offer about its future strategy. That's the point I've already developed. And Phones for You says in it, pausing on that, Phones for You says in its supplemental skeleton 71.2 that the possibility of collusion isn't precluded by the fact that Vodafone hadn't confirmed its final plans. But the reality is that Vodafone hadn't even started to formulate its plans at this time, and the plan was originally to stay in Phones for You. So that doesn't answer the point. So that's the first point. Vodafone didn't have a plan to disclose. And second point, towards the bottom of 343, Miss Castillo was a sophisticated business person, and she wouldn't have offered any commitment or disclosure about future strategy without reciprocation. And that was, of course, Phones for You's own case, paragraph 133 in particulars. Now, the judge, if we go on and look at the first part of 292, the judge makes a finding about the limit of what was discussed. And we could just read down to the reference to 131B4. Now, I showed the court paragraph 131B4. This is a disclosure of intention to reduce reliance on intermediaries in the UK. We say anything Phones for You says under this ground needs to get past the reasoning in paragraphs 291 and 292 in the judgment. And as we said in our skeleton argument, it's really not possible to see how Phones for You does that, because the first point is simply true, that is to say Vodafone didn't have a plan to disclose. That's not challenged. And the second point, that Miss Castillo wouldn't have made a disclosure without reciprocation, it's not just commercial common sense, it was Phones for You's own pleaded case. And so, how is it that Phones for You says this is now called into question? I'm going to focus on the Intel email, which the court already heard about, which is at, I've got a supplementary bundle reference, core supplementary bundle 2165. So we accept that this is an email on which Phones for You placed a lot of weight at trial. And obviously, given where we are now, we recognise it would have been very much preferable if the judge had dealt with the email in the judgment. But the basic answer to this ground is that those points don't support a built-up ground of appeal, and that the weight placed on the email by Phones for You on analysis is totally misplaced. It doesn't mean that the email could plausibly have made a difference in the outcome of the case, and in fact, the more one looks at the email, the more apparent it becomes that it doesn't assist Phones for You.
It's the bottom of the email we need, isn't it?
It's point 4, yeah. But I'm going to take the court through the whole email, if I may. As a starting point, the email doesn't indicate collusion. It just says that Vodafone had some intelligence about what O2 was doing. There was intensive cross-examination about this of Mr. Hum and Mr. Rose. And Miss Rose, we give the references in our skeleton 7164 footnote 8 of the court's note. But nothing emerged in that cross-examination to suggest that Telefonica was the source of this, or to connect the email to Mr. Hum. And the Telefonica witnesses were also extensively cross-examined about it. So this is another inferential case. And my first and primary submission is that nothing in this email undermines the judge's reasoning, having heard the witnesses, as to why there was no discussion of future strategy, no reciprocal exchange in relation to future strategy at the meeting. And the content of the email is not capable of disturbing the judge's findings in 291 and 292, which rely on accepted facts on the one hand and Phones for You's own pleaded case on the other. So that's the starting point. But if one examines the content of the email, there are at least three sets of reasons why it doesn't assist phones for you. Now, the first is that the natural meaning of intel is...
Can we just go up? Where is... Just find where...
I'm sorry. So if I'll show you intel. So it's point 2 is where the reference to intel is. If the court wants to just refresh its memory, and then I'll take the court through the email.
Yeah.
So the natural meaning of intel is market intelligence. Mr. McLean...
Or secret intelligence.
No, our intel, not marketing.
Yeah, I'm going to...
intel.
Secret.
Pardon?
It's secret.
Secret.
Why do you say secret?
Because if it was market intelligence, it would say market intelligence. It's our intel, meaning...
No, my lord, I don't accept that. Intel is simply business people discussing intelligence they've gathered about
I think you look at the definition of intelligence.
Our intel.
In my respectful submission, this is just business people discussing information they've gathered about the sector.
It doesn't say information, it says intelligence.
Yeah. But yes, it's simply shorthand language for business people. Sorry. Let me start.
The implication I would read into our intel is, first of all, this is Vodafone and not market. And secondly, as my lord says, it's intelligence. It's obtained secretly.
Well, my lord.
Well, Cambridge Dictionary, intelligence, secret information about the governments of other countries, especially any governments or a group of people who collect and deal with this information. The same with companies.
My lord, words like intelligence are capable of more than one meaning.
Of course.
And this is business talk between business executives talking about information relating to the sector in which they're operating in. And I'm going to come to what the intel itself is in just a minute. But in my submission, the word intel is perfectly capable of an innocent interpretation. That is to say, information gathered in the market from sources it could be speculation. The phrase Miss Rose used was it publicly available industry speculation and common knowledge. And that is a perfectly...
I entirely accept this is in an email, and it's no doubt open to various interpretations. But I certainly don't think we could just say this is necessarily just a reference to market information.
That's a very fair point, my lord. Perhaps I should have put the point in this way. The word intel in itself is not indicative of collusion. It is simply shorthand language for information or intelligence gathered about the operation of the market. And one has to look at what the intel is and the context of the document as a whole to see whether this is a suspect communication. And in my submission...
I mean, the context doesn't seem to me logically to point to it being market intelligence. She's dealing with, she effectively says, she's sharing some couple of thoughts and some important context. She then goes through various relationships, P4U and EE, and then P4U and O2. Phones for You claim to be in renegotiations with O2 to either bring them back fully in or fully kick them out. And Phones for You tell us that this will play out one way or another by the end of December. Our intel suggests O2 is more likely to align with CPW and carry out or forward Phones for You completely. I mean, logically, Phones for You wouldn't have been telling wouldn't have been telling Vodafone what is stated in the first sentence if the general market intelligence was the opposite. It just wouldn't make any sense. This is really saying, as I read it, that this is what Phones for You are saying. We've got information through or intelligence through the back door, which suggests the contrary.
Yeah, but the point I want to make, my lord, is that the subject matter of the intelligence here has to be seen in context with the intel. And this isn't revelatory. This is someone forming the view that O2 is likely to complete the job it started. Because one's got to put this in context. 12 months prior to this, Phones for You, O2 has made a decision to withdraw new connections from O2. So that's the status. This is starting with a public decision and a publicly known strategy of exiting phones for you, at least for new connections. There was an interesting, if we look at 261 of the judgment, I beg your pardon, it's paragraph 261. Oh, sorry, I've got the page reference.
Paragraph 261 or
Have I got the right reference?
don't think it can be.
Yes. If you read the first quote there, it said, Mark Evans made the point that we are currently half pregnant with phones for you, worst possible long-term state. Now, I'm not sure the description of half pregnant is necessarily apt, but this O2 finds itself in a strategic position where it's already made half a decision to come out of phones for you, and the whole market knows that. It's a public decision. And so it's a natural subject matter to industry speculation about what O2 might do next. Is it? Yeah. Yeah, and the point Mr Hoskins makes is that paragraph 271 of the judgment records that phones for you knew by the 10th of October that O2 was going to complete the job and come out for upgrade. So the decision had been made at that stage. So
Well, indeed, that's what, going back to the Cindy Rose email, that's what it seems to say in the next sentence. I think P4U know this.
right, yeah. So the first point I make is that this is not suspect content. This is a perfectly legitimate subject matter for industry speculation. And given that Vodafone is seeking to develop its own, beginning to develop its own strategy, it's perfectly legitimate for it to be seeking to form views about what its competitors might do. And neither the word intel, nor the content of the information in this context, nor the combination of the two suggest that this is illicitly obtained information. That's the first point.
You're absolutely right, but I think you're accepting that the judge certainly ought to have analysed this and reached a conclusion about it.
Well, I'm accepting that given that it was a document on which phones for you got weight, yes, it would have been preferable if the judge had done that. But what I'm focusing on, my lord, is the built ground of appeal.
And what is your submission as to what we infer about why he didn't?
Well, can I make
Going
my
back to,
can I make my submissions about the email, and then I'll make that, if I may, my lord, because it's an email which the more one looks at it, the less supportive it becomes of phones for use case when one looks at the email as a whole. That's the point I want to make to you. So moving on to that point, if one starts at the beginning, the first paragraph refers to a tied model proposal, see attached. Now, we don't have the attachment, but what we do have in the judgment, paragraph 248, is an explanation of what that tied model proposal was. And can I just read out the paragraph of the judgment for the court? Phones for You approached Vodafone and EE with an offer that each should take a 15% equity stake in return for a renewed long-term contract. Phones for You saw this as a means of cementing their long-term relationship with the MNOs. So the context for the email is Phones for You has made this proposal of a long-term, deep relationship with Vodafone together with EE. So if we then, with that in mind, go back to the points in the email. Point one, Phones for You and EE. What we see here is, this is a reference, I think, to the overlay agreement that we've already touched on. It says, Phones for You has offered us additional volume that would have gone to EE for no additional investment, and we're taking it, being papered now. So it increases the volume share. So that's Vodafone at this point going deeper into Phones for You, taking more volume. There's then paragraph 2, which the court's already looked at, and the only additional point I make about it is that point 2 is presented in the wider context of Phones for You using its negotiations with O2 to put tactical pressure on Vodafone to do a deeper deal with Phones for You. So that's the context. So what is Vodafone's attitude to that? Paragraph 3, what this says is that the tied model proposal is quite interesting and requires serious consideration. So this is not Vodafone in the midst of a collusory plan to exit Phones for You. This is Vodafone giving serious consideration to a deep relationship, taking a stake in Phones for You and committing its long-term future to Phones for You. So that is at odds with the case theory. And what the email then goes on to say is that the likelihood of us being able to commit to it or any variant by the end of December appears unlikely. So that got me thinking, how could we leverage the current situation for some shorter term gain while we debate internally the merits of the longer term proposal? And paragraph 4 is really critical, my lady. Short-term extension. When I pushed Tim to tell me what minimal commitment he would need from Vodafone in order to kick O2 out completely, he said he'd need a 2-year extension to our current deal. And it goes on to say, I think this could work quite well for us. So this is Vodafone giving internal consideration to what it should do to make sure that O2 exits Phones for You. And part of the way in which it's contemplating achieving that, it is entering into a 2-year extension of its deal with Phones for You. This is completely incompatible, in my respectful submission, with the idea that Phones for You that Vodafone is coordinating with Telefonica or coordinating with O2, or that Miss Rose has intelligence that O2 is committing to a strategy of leaving Phones for You. This is Vodafone trying to develop its own strategy, to plan its own dealings with Phones for You in a way that will make sure O2 leaves, to avoid the risk that it might not do so, so that it can exploit the space it's left behind. So this, in my respectful submission, this document shows the opposite of what Phones for You says that it shows. And it goes on in paragraphs A and B and over the page, where we talk about Vodafone developing a strategy to lock Phones for You in. You see 3 references to locking Phones for You in for 2 years. So what one takes from the email, very clearly in my submission, is that Miss Rose doesn't know that O2 is leaving. She is doing her damnedest to come up with a plan to make sure that O2 leaves Phones for You, to allow Vodafone to exploit the situation for its own advantage. That's what this email is about. And the contemplated means of doing that are for Vodafone to tie itself to Phones for You for at least 2 years, whilst it thinks about an even longer term and deeper tie-up. So when one reads the email beyond the word intel, in my submission, this document shows the opposite of Phones for You's case. And that is, in my respectful submission, why, when it came to it, the judge may not have had the same focus on this email that Phones for You did. Ultimately, when one looks at the email, it's not probative of collusion, and the more one reads it, in fact, the more one sees that it's actually inconsistent with the case being advanced. So that's my second point. Intel's not revelatory. It's not the sort of intel that can only come from Vodafone. The email doesn't suggest from O2. The email doesn't suggest that Vodafone's got secret information. I didn't deal with the words our intel in my submission. There's no magic in the words our intel. That simply means the information we've got, the information we're working with. One can't read into that that it's secret or illicitly obtained information. And then moving to my next point, the submission we made at trial was that even if Vodafone had information from O2 that it had plans to withdraw from Phones for You for upgrades and SIM only, that was inconsequential because O2 had completely come out of Phones for You before Vodafone started to contemplate its strategy. And the judge accepted that submission in the second half of paragraph 292. If we go back to, I think it's 343. And this is the passage starting at the words, but even if that occurred. So if the court could just read from there.
Isn't it the case, though, that maybe I've misunderstood this? The alleged collusive conversations alleged by you are at a rather higher level, the highest level, to an extent, than a lot of the correspondence that we're looking at now.
Yes, but sorry, when you say correspondence, my lord,
well, for instance, this email. and Vodafone's considerations about its options, etc. That's all very well, but what's being alleged is that there were very high-level collusive agreements between the MNOs at CEO level.
Well, as far as Mr. Humm and Ms.
right?
Castillo were concerned, they were senior European executives. But the case was that Mr. Humm had obtained the information and passed it to Mr. Rose, and Miss Rose, and that's what we see in the email. So I mean, you're right, but that's the chain. That's the way the case.
The point is, I think what Friends for You would say is, if Mr. Humm and Miss Castillo had made a collusive agreement, he's hardly going to tell Miss Rose that that's what they'd done.
Well, it was certainly put to Miss Rose that she'd obtained this information from Mr. Humm and that it had come from Vodafone. It was
Is that
intelligence.
the other way around, that Friends for You rely on this email as supporting the existence of the communication?
That's exactly right, my lady. Yes, that's right. But so that's the flow of information. I mean, you're quite right, but the case was put on the basis that that's how it flowed through into the decision making.
I think all that's being said is this information showed that this email supports the contention that Mr. Humm was told something by Ms. Castillo. That's all it's saying. And the judge didn't factor that into his consideration of that allegation. I think that's the only point it's relied upon for at this stage.
That's the point, isn't it?
That's
Yes.
right. My views.
Yes.
That's right. So I've made my submissions about that point, which is to say nothing suspect about the content of the email. When one reads it, it doesn't appear to be illicitly obtained information.
But the point we're looking at now is what's the consequence of the fact that the judge didn't even consider it.
Yeah, but I haven't actually. You're quite right. But the point here.
Excuse me, forgive me. The point I'm putting to you is I think we're spending quite a lot of time looking at the context of the email, but I don't think that's what it's relied upon.
Well, no, but there's another. My lord, I'm afraid I haven't explained the point to you yet, and maybe I should do that now. So, if one assumes that there was a communication, you're then on to the Anic presumption of conduct. Did anything happen in consequence of that exchange of information? I'm sorry if I've taken this too quickly, but that's the part of the case I'm on to now. And what the judge deals with in 292 is, well, he says that even if that occurred, so I'm sorry I didn't unpack that. What he's saying is even if there was a disclosure, and I'll come back to now what that disclosure was, he then goes on to say it was inconsequential. So this is then a rebuttal of the presumption, the Anic presumption, saying that nothing happened. And this is a very specific point, my lord, because what we're dealing with here is the alleged disclosure of a piece of strategic information which became public very quickly because by January, O2 was out. It was out, publicly out of Phones for You. And I've already developed the point that by that point, Vodafone was still planning to stay in Phones for You. So that's why we say that it was inconsequential, because even if it happened, and in my submission it didn't happen for all the reasons I've given, even if it happened, that information was available to Vodafone from public sources by the time it came to consider its own strategy. So it had no impact at all. And that's the point the judge is making in paragraph 292. He's saying it's inconsequential. Even if there was a disclosure, it didn't come to anything, because by the time Vodafone took the decision, O2 was out of Phones for You in any event. So I hope that answers your question as to why we're now going into what happened at executive level.
I think it's probably a convenient moment to have a short break. Between, say, 10 past by that clock, so 6 to 7 minutes.
Right.
Give a message to them. Yeah.
How long have you got?
I'm quite appreciative of it.
And then what?
Oh yeah, got a couple.
So 50.
Half an hour.
So maybe not.
Yeah.
Yes. I suppose we're
Court rise, people.
Yeah.
So, my Lord, I changed direction a bit too quickly there, and I apologise for that. If I could just re-anchor you in the submission I'm making. It's my skeleton argument, core tab 7, page 165, paragraph 79 at the bottom. It says, finally, in any event, the judge rightly found at 292, and focus on that paragraph, that if there had been a relevant exchange of information, the presumption of conduct on the market was rebutted. So that's the point I'm on. I'm sorry I didn't signpost that more clearly, but that's where we are. Go back to 292. We say that in the paragraph I've asked the court to look at. So that paragraph 292 is back around 343. Sorry, no, next page. Phones for you says we are misreading this paragraph, and the judge doesn't find that a future exchange of information, he doesn't find that the presumption is rebutted for a future exchange. He says they say this just relates to Mr. Humm talking about trying to find out how it was going. So it was just a backward-looking exchange. And in my submission, that isn't right for three reasons. The first reason is that there's a reference to paragraph 131b4, which is the disclosure of future strategy, reduction in the reliance on intermediaries, and then the judge says, but even if that occurred, then that he's talking about is what he's just talked about, which is a disclosure of future strategy. That's the first point. He goes on then to say, and I make no such findings since that would be pure speculation. Again, that is clearly him talking about a disclosure of future strategy, because that's the point that he'd said would be speculative. He doesn't think it was speculative to say that there was a discussion of how it was going, because Mr. Humm intended to raise that. But it's speculation to think that there was a discussion of future strategy. And then thirdly, if one just goes on to look at what's actually said, it says, in essence, that by the time Vodafone came to make its own decisions about this, it was a known fact that O2 had exited. It had become public knowledge. That's the point I was making to my lord, that this had all entered the public domain before Vodafone got into its decision-making process. So if and to the extent that it was that meeting that O2 was contemplating with coming out of Phones for You completely, which is what the intel in the email is, speculation about that, then that was in the public domain and known to Vodafone before it made any decision. The judge has expressly found that the presumption of conduct is rebutted to the extent that that was.
Can we just go back to the email now, please?
Yeah.
Just
to
the top.
Come out of Phones for You completely.
Yeah.
And so by January 2014.
Because, I mean, I just wondered whether that ties in at all with what the judge said at 292, where he says,
Did you see
in the next sentence, indeed, Mr. Whiting, that's Mr. Whiting of Phones for You,
yeah,
had told Vodafone UK in confidence in November 2013 as part of the discussion about the deeper partnership that Phones for You was likely to separate from O2.
Yeah, but yes, sorry, that's right. But
I mean, is that the
before that sentence, it says by that stage, the fact that O2 had exited from Phones.
No, that stage is mid 2014, isn't
yes,
it?
but the truth of it is that it had happened by January.
This is not November 2030.
This is November 2013.
No, I just wondered whether, if we go back to the email, whether that item 2 is the R intel, is the information that's come confidentially from Mr Whiting. So it's actually coming from PhonesView itself.
I don't want to answer that question incorrectly. Can I come back to you on that? Because obviously
No, I mean just
there's a question of timing.
the dates may not work.
There's a question of timing. I don't believe this point to be overlooked, my lord. But I just before I answer your question.
But I just wondered whether because I was trying to think about maybe the judge did have this email in mind, even though he didn't actually expressly refer to it.
But what this does, what that does show, my lord, is that this information was not at all around this time, the crown jewels. It was information which is within a very short period of time. PhonesView was telling Vodafone itself directly, and obviously the meeting was September. We're now in November, but by January it's in the public domain. It's in the public domain. And Vodafone at that stage has made no decision to exit PhonesView. It's still planning to do a new deal with PhonesView. So that if there was any disclosure that O2 was going to come out of PhonesView completely, Vodafone knew that from public sources by the time it made any decision. So presumption of conduct rebutted.
Seems it's unlikely that the reference in point 2 to our intel being to Mr Whiting, because firstly, it starts with P4U claim to be in renegotiations, and secondly, it says O2 is more likely to align with CPW.
Yeah,
That's not something they would get
quite.
I don't think we put the case on that basis.
No, that's what my law was suggesting.
No.
No, the point I'm making more is now focused on the rebuttal.
Your real point is that even if the judge had expressly dealt with this email, it wouldn't have made any difference.
Well, he decides that by November, by within no time at all, Vodafone knew from Mr Whiting, and then it was in the public domain anyway. So it goes nowhere. And PhonesView's answer to that is to say, oh, but that's not what the judge found. But in my submission, that is quite clearly what the judge is finding. So that takes me to the last point, which is that PhonesView sees the problem there, and so it sees the fact that this information was public information by the time Vodafone made its decision, and that drives it to make the submission that Mr McLean's made, that the discussion was probably about a future relationship and about the prospect that PhonesView would re-enter, that O2 would re-enter PhonesView. And the short answer to that, and that's paragraphs 133 and 140 of the skeleton argument, and the short answer to that is that that's not what the email says. The email doesn't say that there was a discussion of what O2 might do after the thing it hadn't quite decided to do yet. The email doesn't say that at all. And it can't possibly be said that the judge might have reached the conclusion that there was some totally speculative conversation about the prospect that PhonesView would re-enter, that O2 would re-enter PhonesView at some later point, based on an email that doesn't make any suggestion that there was any such conversation. So that's not what the email says, and frankly, it's totally implausible that Ms Castillo would have been imparting information about what O2 might do after the thing it hasn't even decided to do yet. So in my respectful submission, in the end, notwithstanding the profile that PhonesView gave to this email, the case it advances that this email could have made a difference to the outcome of the case. It is extremely weak at a number of levels, and the judge's the fact that the judge didn't deal with the email in the end doesn't affect the validity of any of his conclusions.
Okay.
So I'll hand over to, unless the court has any further questions, I'll hand over to Mr Hoskins.
Well, I thought you were going to answer my question about what you say we take about. Mr Mitru opened on the law by saying that one has to assess whether the delay made a difference.
Yeah.
Did the delay make a difference to the judge not referring to this email?
Well, I'm going to address that.
Oh, okay. Well, Mr Hoskins is going to address it. My answer to that question was that for all the reasons I've given, it can't make any difference. And the more one looks at it, it in fact says the opposite of what PhonesView said. So the delay didn't cause it. It just in the end doesn't do anything like what PhonesView wanted it to do. That's the submission I was making. Mr Hoskins is going to pick up from there.
So on that particular point, discussion with Mr Mitru about, well, how do you tell if the delay caused the judge to overlook the document? on this particular point, we do know what the position is because the judge tells us what the answer is in relation to this particular document. It's the PTA judgment, core bundle, tab 19, page 475. And it's paragraph 44 where he deals with this email. I invite you to read that and I'll make the submission on it.
Yeah.
The judge tells us, I did not refer to it because I found that the change in Vodafone UK's thinking about phones should occur significantly later. Accordingly, this email was not relevant. The judge does not say, I overlooked it, but it wouldn't have changed my mind. And we're...
He had it in mind, but he didn't address it because he didn't think it was relevant.
He didn't think it would...
And in terms of that conclusion, he makes the point that we are not seeking to appeal the Tim's box meeting. I'm not sure I picked up on the Tim's box meeting, but not to worry.
But what's important is that, of course, because we know that there is no causal link between delay and it's not been forgotten.
No.
This isn't a built-up point again. What this is a challenge to the rationality of the judge's finding that there was no collusion between Castillo and Hum in September 2013. It's simply not a built-up point. And if it's not a built-up point, as I said earlier in one of the other points I was addressing, that's the end of it, because the grounds of appeal are purely put on a built-up basis. If there is no built-up basis, that's the end of that particular ground of appeal.
Yeah.
So there are two further documents under this ground 4C that I will deal with. The second piece of information that is not referred to in the judgment, but our submission is it's simply, again, so peripheral it can't satisfy the Bilta test because we are in Bilta territory here. CSB tab 19. Core supplemental bundle, sorry. Tab 19.
Yeah.
At page 63, so red 63, there we are. Now, this is an extract from notes, handwritten notes by Mr. Varela, who was a colleague of Ms. Castillo at Telefonica Europe. And the part of this note that is relied upon by Phones for You, you'll see a little diagram, you'll see some tram lines, and then you'll see VOD, arrow, CPWH, no tail.
No, I can't see that, I'm afraid.
So, do you see the first tram lines?
I've got it here,
further down the
arrow.
page?
What's it say after that?
So VOD, arrow, CPWH, car phone warehouse, that is short for, arrow, no tail. And Phones for You suggests that this is evidence that Mr. Hum exchanged confidential information about Vodafone's contract with Carphone Warehouse during the September 2013 meeting. That's the weight they seek to rely upon this. And with all due respect, to describe that form of reliance on this note as speculative would probably be overstating the position. There is no indication that this note related to the September 2013 meeting between Ms. Castillo and Mr. Hum at all.
Is there a date on it?
Not on this page.
Well, I mean,
a series of undated.
Has anybody hazarded a guess as to the date?
I'll ask those behind me to check. I'm not aware of a date being fixed.
What does no tail mean?
No tail, I think, goes to the length of the contract between Vodafone and Carphone Warehouse, but we didn't get into the full detail.
Okay.
And so there's no indication to link this to the 2030 meeting between Ms Castillo and Mr Hunt. There is no mention of phones for you in these notes, even if it does relate to the meeting. Judgment, paragraph 122, found that Mr Varela was a frank and honest witness. And in cross-examination, Mr Varela said that he did not remember what this referred to, which is why I can't really help you now, I'm afraid. And in his experience, information of this sort came from the indirect retailers themselves, not from competitors. So, i.e., you would obtain information about your competitors from the indirect retailers themselves, and that ties into a point that was made earlier in response to a question from Lord Justice Phillips about where the judge might have got the idea that information had come from Carphone Warehouse. It was something that happened. This is a completely different context from the ground we were looking at before. The references, I'm not going to take you to the cross-examination. I'll give you the reference. It's CSB tab 57, page 163. It's transcript day 25, page 134, lines 12 to 25. And the same day, page 136, line 7 to page 139, line 2.
I can assist the court by saying, according to my learned junior, Mr Cohen, the date of the document is the 24th of October, so shortly after the meeting between Anic.
24th of October 2013.
2013, yes.
So over a month and 10 days after the meeting.
Yeah.
Not contemporaneous. That's the first document. Again, the submission is simply, this is so down in the weeds. It doesn't even satisfy a Bilter test. And then the second point, the second piece of evidence that I am dealing with is a note, again by Mr Varela, of a telephone call between Miss Castillo and Miss Nemat, who was a DT, a Deutsche Telekom representative on the EE board. And this telephone call took place on the 7th of October 2013. First of all, I'd just like to clarify.
Have we got the note?
I'm so sorry?
Have we got the note?
We have, and I'm going to take you to it. But first of all, I just want to deal with a point in the judgment, and I'll come to the note. If we go to the judgment at paragraph 94, so CB 18287. I'm sorry, I've got the wrong page, give me 1 second. You have the right one. If you could read paragraph 94 while I'm catching up. And just over to the top of page 287, you'll see the sentence, Miss Nemat of DT had at least one conversation with Miss Castillo of Telefonica Europe, of which the subject matter is not reflected in any document, either before or afterwards. And Mr McLean in opening said that was an error of the judge, because we do have a note of the particular conversation that Phones for You relies upon. But with respect, that is not correct. The judge has not made an error, because Ms Castillo's witness statement, so that's supplemental bundle 2, tab 23, page 530, paragraph 57 explains, I've been shown communications dating from June and September 2013 which indicate that 2 telephone calls may have been scheduled between Claudia Nemat from Deutsche Telekom and myself. And we have a note of one of these calls, but not of the other, which is precisely what the judge says in paragraph 94 of the judgment. So there's no error on the judge's part at all in terms of what notes are available in relation to the 2 Castillo-Nemat conversations. And then if we go to the relevant note, that's core supplemental bundle, tab 20. And originally it was handwritten, but this has been transcribed and the translation has been added. And what's relied upon is the entry, the second one down, BT, we do it in reasonable conditions. That's the translation from the Spanish. And as Phones for You sets out in the skeleton, around this time, EE were negotiating an agreement with BT, pursuant to which BT would provide mobile services using EE's network. So there were commercial negotiations going on at the time. Now, Phones for You suggests that this evidence shows that Ms. Castillo was prepared to participate in a discussion in which unilateral confidential business information was disclosed by Ms. Neymar. That's as high as it goes. That's what they rely on us for. But there is no evidence that confidential information was disclosed. There is no evidence that the fact that EE were negotiating an agreement with BT was confidential. Some negotiations are confidential, some are known. But we don't know in this case. There wasn't the evidence to say that the fact that negotiation was confidential or not. And saying you will do a deal in reasonable conditions is not commercially confidential. It's a statement of the obvious. Second point, again, this call had nothing to do with Vodafone or Phones for You. It's not even secondary evidence. It's absolutely out in the periphery. And again, this piece of evidence is entirely inconsequential. The idea that this, or the previous document I showed you, could have caused the judge to come to a different conclusion on Hum and Castillo is, with all due respect, it's far-fetched. It's simply not going to bear that weight. I think that's as finished on the Castillo-Hum Bilta grounds, and unless you have any further questions on those, I'm going to move to grounds 4D and the relevant part of 5, which deals with Mr. Whiting's note. And the judgment here finds Mr. Dunn and Mr. Whiting of Phones for You had a meeting on the 27th of January 2014 after O2 had informed Phones for You that it did not wish to enter into a new agreement with it for upgrades, i.e. O2 was exiting Phones for You completely. And Mr. Whiting took a note of that meeting. And you've seen that note, and we'll go back to it now. It's in the, I believe, let's check. Yes, this time it's in the core bundle, I think, sorry. We'll take it from the judgment, that's the easiest place. Core bundle, tab 18, page 340. You've been shown this and you've been through it. So you see, I'm sorry, give me 1 second. Para 276, so we need to go down a bit, please. Thank you. Yeah. So there's the note there at the bottom of the page. You want to refresh your memory. This is what Mr. Whiting said that Mr. Dunn told him at this meeting in January 2014. If we go to page 342, paragraph 286 of the judgment, the judge states there that the critical question is not what Mr. Dunn may have said to Mr. Whiting on the 27th of January 2014, but whether in fact such commitments were given or such information was exchanged between Telefonica and Vodafone regarding O2's exit from Phones for You. That's actually what the critical issue is. That's the alleged collusion. And of course, as we've seen, the judge found that no such exchanges took place. So in relation to the critical question, that's what the judge found. So this is, again, a second order, though clearly an important second order evidential issue. Paragraph 305 of the judgment at page 348. The judge found that Mr Dunn had said these things to Mr Whiting. But the judge found that what Mr Dunn had said was not true, and that Mr Dunn had said these things to avoid taking any responsibility for the decision to exit PhonesView. He was trying to say, it's out of my hands. If we go to paragraphs 308 to 310, I invite you to read those, please. I don't think you've seen them before. And I should say that Messrs Whiting, Dobson and Lloyd were all PhonesView witnesses. So you have Mr. Lloyd, who was the senior lawyer in PhonesView, saying it was difficult to believe that Mr. Dunn would have made the statements he did had they been true. That would have risked frustrating the very scheme whose existence he had purported to disclose. It was like robbing a bank and telling everyone you have done it. I queried whether Mr. Dunn was playing mind games with us, seeking to undermine the trust between PhonesView and Vodafone UK in order to damage that relationship. That's Mr. Lloyd's view. 309. I note that when first discussing the conversation in the car park, Mr. Whiting and Mr. Dobson wondered whether it was just a very odd strategy of Mr. Dunn to avoid taking responsibility for the decision to exit PhonesView and dealing with the consequence of that decision. And then at the bottom of 309, as Mr. Whiting put it in his evidence, Mr. Dunn's whole demeanour at the time was very much, sorry guys, there's nothing I can do about it. This explanation, that Mr. Dunn made it up to give the impression that the decision was out of his hands, was adopted by Vodafone in their counsel's closing submissions. And I should say, we also put this point in our closing submissions. It's paragraph 106. I don't need to take you to it, it's just if the other side want to confirm that. So both Vodafone and we, on the basis of PhonesView's own evidence, made the submission that the judge subsequently accepted. It wasn't our primary case, obviously. But we said if you don't accept our primary case that Mr. Dunn didn't say these things, then here's another explanation. And putting it shortly, PhonesView's attempt to overturn this finding, which is based on the evidence of PhonesView's own witnesses, has to be given short shrift. Mr. McLean in opening made the point that it would be odd if what Mr. Dunn had said about Mr. Swanty were true, that Mr. Swanty wasn't open to talking about distribution, but that what he had said about Mrs. Alierta and Kalau and Ms. Castillo and Mr. Hum were not true. He said it would be odd to have something true and something not true. But that, again, is simply not a NatWest and Britta point, because the judge did take account of what Mr. Dunn said about Mr. Swanty in his judgment. If we go to paragraph 307D on page 348, you'll see 307, sorry, if we just have the 307 first. However, I prefer Mr. Whiting's evidence of the conversation for several reasons. And then if you look at the reason at sub D, he expressly takes account of the fact that what was said about Mr. Swanty was true. So this cannot be a Brita point, yet again. It's simply a bare challenge to the judge's finding, and the judge cannot be said to be clearly wrong outside the reasonable scope of exception. And in any event, as you know, you see it for example, paragraph 304, page 4347, the judge found that there was no collusion between Mr. Alerta and Mr. Kalau. So on that basis, what Mr. Dunn said about Mr. Swanty was true, but what he said about Mr. Alerta and Mr. Kalau was not true. It's absolutely within the judge's scope of reasonableness to find that what Mr. Dunn said about Mr. Hull and Mr. Castillo was also not true. If he'd lied about the Mr. Alerta and Mr. Kalau, not surprising indeed that he had also done the same in relation to Mr. Hull and Mr. Castillo. But it's simply not a built-up point. Ground 5, so this is again the failure to consider in the round. Points for you suggests that the judge failed to consider whether his conclusion that Mr. Dunn was lying was improbable in light of what was discussed at the Hum-Castillo meeting in September 2013. You see that, for example, in their skeleton, paragraph 188. That's core bundle, tab 3, page 75. If you'd like to refresh your memory of the point that's been put. But again, with respect, that's simply not a correct statement of what is in the judgment. If you go to page 349, paragraph 311, so we just looked at 308 to 310, where the judge reached his conclusion that Mr. Dunn did say what he said, but it wasn't accurate, it wasn't true. And then at 311, the judge said, I've considered carefully what impact my finding that the conversation indeed took place has on the assessment of what Mr. Dunn said was true. In my judgment, it does not affect that determination. All the reasons remain for holding alleged collusion between O2 Telefonica and Vodafone is most unlikely. And as Mr. Lloyd pointed out at the time, it is just as curious that Mr. Dunn should have made these remarks if they were true as if they were not. So he's considering the position in the round. Again, it's simply not a built-up point.
Well, that was the point that Mr. Lloyd said. Well, if it were true, then it's very odd to have effectively said it at all. I mean, yeah, right.
Well, we talked about the smoking gun.
Footy shooting something, but certainly it's the self-inflicted wound either way, isn't
exactly.
it?
But it's not a built-up point.
No.
And the grounds
Well, no,
are all on the basis of built-up.
Yeah. As you say, the judge dealt with it.
So those are the submissions that I wish to make on that particular ground. Mr. Williams has some other points.
Yeah.
A few very short points on that. So I only want to emphasise one point, which is the state of the case relating to Mr. Kalau by the time we got to trial. Because what Mr. McLean said yesterday, or I think it was yesterday, was that it's not common ground that the part of the note relating to Mr. Kalau is false. He says, I simply failed to prove my case. And that is masterly understatement by Mr. McLean, and really doesn't give a true sense of the state of the case in relation to Mr. Kalau by the time of trial. The position is that by the time we got to trial, the allegation that Mr. Kalau had received commitments from Mr. Alierta was so obviously baseless that even a skilled cross-examiner as Mr. McLean didn't have a credible basis on which to put the content of the note to Mr. Kalau. One sees that from the judgment. And if we could just pick up the judgment at paragraph 298 on page 246. No, sorry, do I mean... Yeah, sorry, I mean 298 246, I'm sorry.
Paragraph 298.
298, yes. Page 246, rather than 346. My mistake. Oh no, it's not. I'm so sorry. I'm sorry, I've got my wrong reference. It's 345, I'm so sorry. Yeah, so here's the section of the judgment dealing with Mr. Alietta and Mr. Kalau, and if we could pick it up at 298, and I'm just going to draw out a few points for the court's note. 298, middle of the paragraph, the judge says, I found Mr. Kalau a very impressive witness who answered questions directly, and it seems he was the only defence witness who hadn't received witness training. Now, I don't have time to ask the court to take the detail in now, but 299 makes an important point, which is that Mr. Kalau was on record at the time as being extremely sceptical about Vodafone UK's strategy of leaving Phones for You. And the judge makes the point that that raises credibility issues in relation to the allegation that he had been instrumental in putting in place a collusive strategy to bring about the thing which he was then vocally opposed to internally. So this is another inconvenient aspect of the contemporaneous record which Phones for You just ignores. If one then moves on to 300, this makes a point that it's inherently implausible to think that group chief executives responsible for operations across Europe and across the globe would take such a granular interest in these sorts of specific contract negotiations at UK level. And that paragraph says halfway down, having found out, sorry, so he says they wouldn't have exchanged information. He says, I'm clearly of the view that Mr. Kalau never gave Mr. Alietta any commitment as to Vodafone's future conduct or received any commitments in return. So it's absolutely as clear as day. And the paragraph also notably goes on. I'm sorry, if we just move on to 30. And if one looks at the bottom of 300, it says, Phones for You notably alleged this occurred around mid-September. No doubt to sustain their case, this influenced O2's decision making, but and this is the point I've already made. At that time, Vodafone didn't have any such strategy. And if one then looks at 301, this is the extent of the case that was put to Mr. Kalau. It's a case that in July 2014, he engaged in discussions about market repair. So first of all, it's not the content of the Whiting note. Secondly, it post-dates the Whiting note by 6 months, this incident. So it couldn't possibly have anything to do with what Mr. Dunn was supposed to have revealed to Mr. Whiting. So essentially, the case completely collapsed in isolation. And I would ask the court to note also paragraph 303, where the judge expressly took account of the lack of documentary evidence relating to Mr. Alietta for reasons that have already been canvassed, and took that into account, noting that in fact he did have the benefit of disclosure of Mr. Kalau's emails, and in fact he had disclosure of other materials such as personal emails and mobile phone data, text messages and so on. So that's why we say this part of the case collapsed. The judge rejected the case in the clearest terms. This case wasn't not proven. The judge made express findings that Mr. Kalau wouldn't have done and didn't do the things he was accused of. This is a classic issue for the trial judge, who had the benefit of hearing from the witness who was held to give impressive and honest evidence. Those findings could never be challenged, and they haven't been. And so that's why we say that the note, as it related to Mr. Kalau, was false. And on that basis, we say that this argument that one can't rely on, that the note is inherently unlikely to be true in part and false in part, it just falls apart, because it was undoubtedly not true in relation to Mr. Kalau, and there's no reason to treat it as having been anything other than untrue in relation to Mr. Haynes here. But that's the only other point I wanted to make in relation to that ground. Unless the court has any questions.
Right.
And also, Lady, I'm going to now address the court on ground 4E in relation to the exchange between Mr. Sheehan and Mr. Hunt. And this really is a challenge to the facts dressed up as an error of law, you'll recall that my learned friend advances a filter argument saying that there are two strands of evidence that the judge failed to refer to in the judgment, and on the basis of filter, argues that had the judge had those two pieces of evidence in mind, this court can't be satisfied that the judge would have come to the same conclusion. And the two pieces of evidence that are identified by my learned friend are firstly the email of the 31st of March from Mr Nolol, and secondly evidence showing that both Mr Sheen and Orange itself were sceptical about the merits of an acquisition of Phones for You. So those are the two things that the judge is said to have omitted to refer to, and they form the springboard for the filter ground. And as I'll show the court, the judge did refer to both strands of evidence in the judgment, and so the argument doesn't get off the ground for that reason. And really, in reality, what the appellant is saying is that it would have liked the judge to have placed different weight on those strands of evidence, and that's classically impermissible territory on appeal. But there is an even shorter answer to ground 4E. And to see that, I need to go back to the section of the judgment addressing the Sheen-Hum exchange. So the discussion starts so it's tab 18 of the core bundle is the judgment, page 420. The passage starts here.
Paragraph.
Paragraph 562, my lord. And I know that you've seen these passages already, but I want to emphasise a few short points. So if we move to paragraph 570, so you've seen already, I think, at 566 and 567, the follow-up messages after the short 5-minute call that took place, which is referred to at 565. So you've seen the sequence of events. Mr McLean took you to those. And then what we see at 570 is the judge found that it was inconceivable that Mr Hum would not have asked what the topic was on the 5-minute call that Mr Sheen wished to discuss. In which case he said Mr Sheen would have answered the question, although I accept he may not have entered into many details. Mr Hum accepted that he must have learnt enough to think it worth meeting. And then if we can go over the page, please, page 422. And if we look at paragraph 572, although it's possible that Mr Sheen only said to Mr Hum that an interesting joint opportunity for their two companies had arisen in the UK, I think it's likely that Mr Sheen went further and referred to the potential for change in the UK market following the announcement of the Dixon's Carphone Warehouse merger discussions. Mr McLean stressed that the conversation lasted almost 5 minutes. Nonetheless, I do not accept that a more substantive conversation took place. In my view, the initial telephone call was a prelude to what Mr Sheen proposed to pursue by a full discussion to be held either in person and then on the secure phone once he realised that he couldn't travel to London in time.
Yeah.
Now, here we have a finding of fact by the judge that the conversation did not go any further than what he identifies here, that a reference to the potential for change in the UK market following the announcement of the Dixon's Carphone Warehouse merger. And the judge then goes on to discuss at 574 what he considers it's likely Mr Sheen wanted to discuss at that further meeting or call had it taken place. So that's the analysis at 574. And what the judge identifies in 574 as being the likely topic for the future discussion that never took place was the joint acquisition of Phones for You. Now, at 575, just over the page, you see the judge found that Mr Hum realised that Mr Sheen was seeking to enter legally sensitive and potentially forbidden territory and deliberately pulled away. His reference to the presence of a competition lawyer is significant. It may be that Mr Hum's final text message was strategically worded and he knew a little more about the proposed topic, and it may be that he was therefore being less than entirely frank in his evidence, but that doesn't matter. I find that no exchange of confidential information actually occurred. And in particular,
Well, I mean, the real point he's making is that, in all probability, Mr. Hum must have known, and that it must have gone. There must have been some discussion as to what it was he wanted to talk about. It was a 5-minute call, so he knew jolly well what it was he wanted to talk about, but he didn't go anywhere near it. And so what he's really trying to do is distance himself in two ways. One by, as it were, the pretext of saying, well, I don't know what you want to talk about, even though he did. And secondly, by saying, I want a competition lawyer present before we go any further.
My Lord,
And that then it is sufficient to effectively frighten Mr. Sheen off.
My Lord, that's what the judge is saying there, but critically for my purposes, the judge has made a very clear finding of fact, and we see this in 572 and 575, that the limit of what was discussed in terms of flagging the subject matter on that 5-minute call was, and you see it at 572, the potential for change in the UK market following the announcement of the Dixon's Carphone Warehouse merger discussions. And you see at 575, the judge is finding a fact that no confidential information was exchanged on that call. And so really the short answer to this bill to point is that my learned friend says, well, the judge was wrong to find at 574 that the topic Mr. Sheen wanted to discuss in the future was the joint acquisition, because had the judge taken account of the Nolo email and the scepticism of Orange, the judge would have come to the conclusion that actually the topic of conversation was collusive, jointly leaving Phones for You. But really the short point is that goes nowhere because of the prior finding of fact that no confidential information was exchanged on that 5-minute call. And the omissions that my learned friend relies on, the omissions, which are not omissions, I'm going to show you that in due course, but let's assume they were omissions, let's assume he was right on that, they're just incapable of disturbing the finding of fact about the limited discussion that took place on the call. That's really the very short answer to ground 4, and it's the answer the judge gave in his decision refusing permission to appeal. So in a sense, the question of what Mr. Sheen wanted to discuss in the future is by the by, because the judge found that conversation never took place. And we have these clear findings of fact which are not challenged in 572 and 575 of this very limited discussion. And it's not surprising, may I add, that the judge found that the conversation was so limited, because even though the purpose of that call, of course, was to set up a meeting. Now, my learned friend said, well, it was almost 5 minutes. But there were other relevant factors which the judge would have had well in mind, including that Mr. Sheen and Mr. Hum didn't know each other at all, including that Mr. Hum took the call at an airport in a public place, and he explained in his cross-examination, when he was cross-examined, that he would not have wanted to have had a detailed conversation about sensitive matters in a public place. And when one looks also at the terms of the text, so if we go back to 421, now, the judge, of course, found, my lord, as you just identified, that Mr. Hum may well have been sensitive about the suggestion by Mr. Sheen that they use a prepaid number, phones with prepaid numbers. And so when he answered, he said, hello, Benoit, not knowing what you want to discuss, I feel not comfortable in making these sorts of arrangements.
I suppose the other way of looking at it, I mean, I know it was a 5-minute call, but whatever it was that he said in the call, it didn't really, it was just a sort of an opening gambit.
Exactly. With
the intention that anything that was actually confidential would be dealt with on the burner phone. And Mr. Hum's response to that was that he wasn't comfortable with it. Because the moment he mentioned the burner phones, anybody with any common sense would think, well, hang on a minute, he wants to discuss something that's improper to discuss.
My lord, that's precisely the point. And that's exactly what the judge found. And you see that at 574.
Yeah.
I consider that what Mr. Sheen wished to discuss, so he's talking about what he wished to discuss, that's his finding on the balance of probability. But then he says at 575, he makes exactly the point you've identified. I find Mr. Hunn realised that Mr. Sheen was seeking to enter legally sensitive and potentially forbidden territory and deliberately pulled away. And then he says, I find no exchange of confidential information actually occurred. And that really is the short point. And if you go, please, to the judgment refusing permission to appeal, which is at tab 19 of the core bundle, page 475, paragraph 46. I just ask you to read that paragraph. That is the judge making the point I've just made. He makes it much more pithily than I have.
Yeah.
So that's the short answer. I have a longer answer. I think I can do it in 15 minutes, if you'll bear with me, but I may not quite finish. But we're I think we're now back on track time-wise. So,
okay.
And so there are further reasons why this ground is incorrect. So applying the Bilter test, and the 2 points in summary that we have under Bilter are first that the judge simply did not omit to refer to the evidence about the Nolo email and Orange's scepticism about a merger. So he had those well in mind. And the second is, and so just pausing there, the evidence about scepticism about the merger, that's all over the judgment, I'm going to show you. So there just simply is no conceivable argument, and I just don't understand the basis on which the point's been put, that there's any omission. And the point about the Nolo email, my learned friend fairly took you to the 2 paragraphs in the judgment where the judge did refer to the Nolo email, so he obviously didn't forget it. The point made by my learned friend is a very narrow one, which is that he didn't go on to refer to the fact that it had been forwarded to Mr. Sheen. Now, if that's said to be an omission, and we say that, again, thinking about causation and Bilter, it's inconceivable, really, that the judge forgot about the email because he referred to it in his judgment. But if it could be said that, well, he forgot that it was forwarded to Mr. Sheen, really that email is just incapable of making any difference to the judge's conclusion. And that's aside from my short answer. Now, can I take you back, please, to the judgment, so tab 18, page 387. And before taking you to these passages, let me just foreshadow what my submission is going to be. So my submission is going to be that the judge had well in mind that Orange and Mr. Sheen were sceptical about the joint acquisition. But what was going on here was that EE was keen on the idea of a joint acquisition and had specifically mandated Orange and DT to go away and work up the proposal. And so in that context, which of course my learned friend skated over, did not mention, in that context it's not at all surprising that the judge reached the conclusion that the likely topic of the future conversation was the joint acquisition of Phones for You. So starting at paragraph 445 of the judgment, what you see here is the timing of the announcement of the merger between Carphone Warehouse and Dixon's, or at least the discussions about the merger on the 24th of February 2014. And it was a complete surprise for EE. And Mr. Swanty said, we see this at the end of that paragraph, that it was a real game changer, and several of the other witnesses said the same thing. So it was a shock in the marketplace. And what then happened is that EE canvassed different strategic options, and we see those at paragraph 447 over the page. And those options include acquisition by EE, and it says unlikely to be economically viable, but acquisition by EE and another operator, not viable beyond a particular valuation, so potentially viable. And the slide pack for this meeting, the meeting which took place on the 20th of March 2014, also considered the implications for Carphone Warehouse if there was simultaneous exit from Carphone Warehouse, but there was no consideration of simultaneous exit from Phones for You. And the merger was discussed at the BRM, we see that at 449, and my learned friend, you'll remember, took you to a section of the minutes of this meeting and took you to Mr Sheen's comments at that meeting, but you'll see in this paragraph that the judge had very well in mind what Mr Sheen said, because he says in terms, Mr Sheen said that if the merger went ahead, it may make sense to exit Phones for You. So that's a point that the judge plainly didn't forget, he had it in mind. Then at 450, Mr Nolol said that there was no consensus about how to proceed in the light of the merger. Various possibilities were discussed. And then at 52, on page 389, active consideration was given to the potential of acquiring Phones for You with another MNO, probably Vodafone, with a view to breaking it up and absorbing its retail estate. That idea was strongly promoted by the EE management. And Mr Pereira asked Mr Eyre to model a potential acquisition. And then this, at the BRM, it was agreed that the M&A teams at DT and Orange should consider the possibilities. So they were tasked with going away to consider this. And indeed, there was follow-up. So Mr Harris and Mr Milsom followed this up with Mr Nolol and Mr Knieser. Mr Nolol put Mr Milsom in touch with Mr Froissart, who at this time was Senior Vice President M&A at Orange. This was all with a view to considering the joint acquisition. And then we see 454, matters moved quickly. And then 455, there was a call with slides about the joint acquisition. That was on the 25th of March. And then 456, and there's a reference to an email from Mr Froissart to Mr Nolol. Now, this email of Mr Froissart's was one of the cornerstones of Phones for You's argument at the trial, because what he says in that email is there is a historic opportunity to strike a blow at indirect distribution, but it's tricky because it needs cooperation with Vodafone. And Phones for You said at trial, aha, that means collusively exiting Phones for You. But the judge considered that very carefully and concluded that it didn't mean that. And we see, following cross-examination, obviously, of Mr Froissart, we see over the page that the judge found, as a matter of fact, that the reference to the necessity for cooperation was because the proposal for an acquisition was being put forward as something that, in terms of cost, EE would have to do with another network, for which Vodafone was the only realistic option. Mr Froissart, of course, was part of the M&A function that had been tasked with going ahead to look at this option. And the judge says, I accept that evidence. So the unique opportunity that's being referred to here, the historic opportunity, is a historic opportunity to do something about indirects, but particularly what's being considered here is a joint acquisition of Phones for You. And then we see at 457, EE's management continues to promote the strategy of an acquisition of Phones for You, with a view to this being tabled at the next BRM to be held on the 10th of April 2014. Now I'm going to have to come back to this tomorrow, but just pausing here, what we see then, just at the very time of the Sheen-Hum call, is active consideration by Orange. So everybody appreciates that this is...
So the context.
The context.
For Mr Sheen's conversation with Mr Hum is that even though Mr Sheen may have been personally sceptical about joint acquisition, his superiors were pretty keen on it. And so he may very well have been told to get on with it. Or he may have decided to do it of his own bat, I don't know.
So nobody at Orange was very keen on it. They were particularly not keen on the idea of an acquisition with a view to breaking up the company. But what they were being told, so Orange and DT, Deutsche Telekom, were the parent companies. EE itself was keen on this idea, wanted to take it forward, and EE tasked Orange with going away to investigate it, and Orange got its...
And in parallel with that, Mr Sheen is, who is EE?
Mr Sheen is Orange.
But he's working in London for EE at the time.
So he's a director of EE, so he's one of the directors. And so what we see is a recognition that the Carphone Warehouse Dixon's merger is a game changer, presents a historic opportunity, is what Mr Froissart said, and the option that's being considered at the time is a joint acquisition. So even though neither Mr Sheen nor Orange are very keen on it, that is what's being explored. And I'm going to come back tomorrow morning to show you how the judge had very well in mind that Orange was sceptical about this.
Okay. Right, well, should we do that tomorrow in that case? We're well on course, aren't we?
We're well on course.
Okay. 10 o'clock tomorrow morning, please.